I'd like to start with just a moderator's privilege with a few framing remarks because this topic of religious liberty and education is one that is near and dear to my heart. In some ways, I've been involved in this topic and this battle to advance religious liberty throughout my professional career, particularly through what we call in the United States the Parental Choice movement, which promotes policies that give parents resources to enable to choose their children's schools, including private and faith-based schools. I am very grateful that this movement has gained steam in the last few decades, and this last month was like a huge victory month, like a victory lap for the school choice movement for a couple reasons. The first is the decision in Carson versus Macon. The Supreme Court of the United States held that our free exercise clause prohibits government from excluding faith-based schools from school choice programs. I was actually among the first lawyers. I was on the first legal team to challenge the exclusion of religious schools from the program at issue in Carson versus Macon when I was 26 years old in 1996, and we lost, as did 7 other teams of attorneys. But in this case, justice delayed turns out not to be justice denied. So I just saw Justice Alito walk in, and I'd like to thank you for helping the world to know that I've been right all along. And the second major victory for school choice this month has been the state of Arizona, I think about a week ago, enacted the first universal school choice program that gives every student in the state, and I'm sorry, this is emotional for me, an education savings account worth $7,000 to attend the school of their choice. So it's been a good month for me and the school choice movement. But more recently, my work has expanded internationally, and I've had the privilege of working with Father Bahina, with Augusta and Ana Maria on religious liberty issues facing Catholic and faith-based schools globally. And one of the things I really learned from them and others, including Paul Barber, who's the head of the director of Catholic education in England and Wales, who's here, is that it's really important to study these things comparatively, because in the United States, we have always really focused on funding because we don't have it. But what we do have is freedom for Catholic and faith-based schools. So we have a lot of freedom in the United States, freedom to hire and fire our teachers, thanks to the ministerial exception, freedom from most curricular requirements, and freedom over enrollment. And what I've learned working globally, especially I think I learned this first from Augusta, is that in many other parts of the world, public funding is available, but faith-based schools don't have freedom. And so battles over religious liberty in Kenya and Chile look a lot different. They're really not about money, but they're about autonomy. And finally, there's the issue of the religious liberty and education concerning the rights of teachers and students in public schools. Again, the Supreme Court's recent Kennedy decision illustrates this, because in the United States, our schools are secular. Public schools must be secular, but we have rights. Even students and teachers have free exercise and free speech rights within them. That's a difficulty. But in other nations, students actually have the right to religious instruction in public schools. And then there are all kinds of complexities, as illustrated by a recent case, the Paves case in the Inter-American Court of Human Rights that I think Ana Maria will probably mention, which held that the Catholic Church violated the rights of a public school teacher when it withdrew its authorization for her to teach Catholic doctrine in a public school. So this is a very strange thing for us in the United States. So I think this is just a really interesting and important topic. And I look forward to hearing about these challenges and others from our panelists. They'll each speak about 10 minutes. We'll start with Father Bahina, who's going to give us sort of a global overview, and then we'll move to Latin America and then East Africa before hearing from Brett. So Father Bahina, thanks for being here.
Yeah, thank you, Nicole. Thank you, Dean Marcus Cole, and all the others. I'm really impressed to have such a strong group, such a strong team here. And I was impressed by the opening address, where I learned that what you can see in your faces, that these people who are burning for something, who are passionate for something that can change the world to the better. And I think this is our purpose. That's why we are here. That's why all of us somehow are working with or in Catholic education as well. And bringing together these two topics, religious liberty and education, brings us also to the point that liberty is a very complex concept, as the world today is complex. Sometimes it seems to us chaotic, and that means no single one can have a view of everything. And we will only succeed in our aspiration in what we are doing if we work together. It's a challenge because the diversity of Catholic schools, we have 220,000 Catholic schools worldwide, 1,500 Catholic universities. Every single is different from every other. And the expression of the religious liberty and the situation in which one school or one university is acting is as well diverse and different from all the other situations. We have to deal with different legal systems, different cultural and historical traditions. And that makes it enormously challenging. And therefore, I just want, departing from my own experience, to try to distinguish at least some of the concepts with which we are working when we're speaking about religious liberty in the context of education and specifically in Catholic education. When the concept of religious liberty appears in letters and documents sent to the Congregation for Catholic Education, and a great part of it come from the United States, interestingly enough, because they have good lawyers who know how to formulate these letters and recourses, they typically refer to three areas of religious liberty. The first one, which was already mentioned, is parental choice. So it doesn't help if I have a liberty, but then it doesn't become realistically also in practice. So if I have choice, but then would have to pay a tuition fee which I cannot afford, then it's not a real choice, and I'm not free to enroll my kids in Catholic education if it's not affordable. So typically the cases brought to us in the question of parental choice is either that people want to help to ask the assistance of the Holy See via diplomatic possibilities to intervene. This probably is not typical for the United States, because there you resolve your issues diversely, and the diplomatic intervention of the Holy See wouldn't make a big difference, or on the other extreme could be even counterproductive. But in many countries, a diplomatic intervention could be reasonable and a way forward, because there is what we call concordats, so agreements on the cooperation of state and church in the field of education. And there the Holy See has also a saying diplomatically. Or what we can try is to involve, to engage people at the spot. This is also something which, with our channels of bishops' conferences, of nuncios, of religious orders, we can try to streamline policies to guarantee that there is not only the law, the legal fundaments to have this choice of school, which we believe is a fundamental right of parents to make a choice. Actually, our church documents recommend to enroll their children in Catholic education, in Catholic schools. But this is a first area, the question of parental choice. A second one is exceptions of faith-based schools from certain laws. This is a typical discussion in the United States, and it's very diverse again in different countries. In some countries, Catholic schools are public schools and would follow all the legislation. They would have the same curricula. They can add something to the curricula, but they cannot fundamentally change, because learning outcomes are defined by a supervisory authority of the state. And then there is the question, what does a constitution of a country prescribe for everybody? And obviously, Catholic schools must also navigate within the rule of law and respect laws, for example, labor law or security law or other laws. But then we have also to look where the Catholic Church can also ask for a certain freedom, for a certain exception. We had very recently, but not in COVID debate already before, the discussion of exception if there is an obligation for vaccination for kids to be enrolled in school. This is something which then can also come as a recourse to us. But there we have to see, does the church in her doctrine say that vaccinations are not morally, for example, other religious groups would have this and then get in the United States exemption. Meanwhile, you cannot easily refer to this, to your Catholic faith in getting exemption from vaccinations. That's we have the results of the courts in the United States. And the third question is the ministerial exception, as it's called in the United States. So it's the question: how much is the church free in leadership, in hiring and firing in the Catholic schools? You would know the cases that are around, but also there's a quite variety on legal approaches in different countries. I shall not provide a complete and extensive answer to the question of religious liberty in the context of education, but hope that our discussion later on will help to understand both the complexity of this question as well as some possible and pertinent answers to it. As the basis of the question, we may identify the principal problem of relationship between state and a modern democratic, liberal and pluralistic one as we are used to live in, the individual human person, civil society, churches, religions and other faith groups, as well as any form of association and NGO. So there is this difficult interaction of all these players, and everybody has or pretends to have its autonomy in certain areas. And to balance this, I think this is the main question of liberty. But liberty is not just something which I can ask for myself, but I also have to grant, to provide for the others. And when today the Dean mentioned it briefly in the opening address, that also the Church had a kind of new interpretation, new formulation of what our main principle is, which Jesus said, give to the emperor the things that are the emperor's, and to God the things that are God's. And people were utterly amazed at him. And I think it's still an amazing affirmation, amazing question. But actually this is the fundament for us from our faith. And this is what we want from the state, but it means also that we have to recognize the same autonomy of the state. So give also to the emperor what belongs to the emperor. And we remember that there had been times, not in the United States, but in Europe, where the Pope or the bishop told the emperor what they had to do also politically. And I think we have to balance this. Therefore, it's a question of mutual relation when we speak about religious liberty. I don't want now to go more in detail. We will have this in discussion, but just mention some of the different models of this relationship. So we have a secularistic model, like after the French Revolution, in the French laïcité, so that a state would pretend to offer neutral education, but we know that neutral education is not existing. Education has always to do with goals, has always to do with sets of values for what you educate, and there is no neutral education. And we always believe Catholic education is as neutral or not neutral as the others. Everybody has its sets of values, but we hope to be transparent about them. And some others are probably not, and following the political trends in a country. Then we have a totalitarian or ideologically restrictive model, where some authority, being the church, being the state, imposes set of value and does not grant the freedom of religion. And we have a religious model in case of legal or the de facto state religion. And in the pluralistic model, we have those where all are equal. We have a majority model. We have a legal constitutional model where there is approved religions and not approved religions. We have totalitarian models where one is favored. We have restrictive models where faith-based education is somehow tolerated, but at the same time somehow also discriminated. And we can also have today a restrictive model where legally there is freedom, but by mainstream or political correctness, it's very difficult to maintain religious liberty and Catholic or other identity. Thank you.
Thank you, sorry.
No, yeah.
So, Sandra Pavés was a Catholic teacher in a public school in Chile that filed an appeal when the religious... What?
They're having a hard time hearing you.
Oh, okay. May I continue, or you didn't? Okay. So Sandra Pavés was a Catholic religion teacher in a public school in Chile that filed an appeal when the religious authority took away her suitability certificate. In fact, the Vicar of Education made the decision when he learned that the teacher was living together with a same-sex partner in contradiction to the beliefs that she should teach as a Catholic teacher religion professor. After the appeal and the Supreme Court denied Pavés' petition by confirming the decision of the competent religious authority, she continued before the Inter-American Commission, who presented this case before the Inter-American Court, pointing out Chile's responsibility for the violation of judicial guarantees, the right to private life and autonomy, access to public function in conditions of equality, equality before law and labor law. This year, in February, the Inter-American Court of Human Rights condemned the state of Chile. Although the case was not presented invoking religious freedom, obviously it was at stake. In this regard, the court's decision indicates that Catholic religion classes in public schools and with public financing of such classes does not constitute an area of religious freedom exempt from state authority. The Pavés versus Chile case restricts the autonomy of religious communities to certify the suitability of religion teachers of confessional classes in public educational establishments. The Inter-American Court concluded that the state was responsible for the violation of rights that would have been affected by the revocation of the suitability certificate by the religious authority, as the right to equality and non-discrimination, the right to personal freedom, the right to private life. The state would also be responsible for the violation of the right to judicial guarantees and judicial protection, and considering that the judicial authorities did not carry out an adequate conventionality control of the act of the school by which Sandra Pavés was separated from her position as a teacher of religion, although she stayed in the same school in another role. The state was also considered responsible for not contemplating effective remedies in the Chilean legal system to challenge the effects of the decision to revoke the suitability certificate. On the other hand, the court considered that there was no violation of the rights of access to the public function under conditions of equality, considering that teaching in a public school and receiving public funding meant she's a civil servant. Despite having condemned the state, Professor Soledad Bertelsen, ex-alumni of the law school at Notre Dame and professor of international human rights in Chile, underlines the decision has some positive aspects for religious freedom. First, the Inter-American Court did consider that the case involved a potential violation of the freedom of religion enshrined in Article 12 of the American Convention on Human Rights, an aspect that the Inter-American Court omitted in its background, the Commission omitted in its background report. Secondly, the court recognizes the individual and the collective dimension of religious freedom. Thirdly, the court reaffirms that the decree that establishes this certificate of suitability given by the competent religious authority, the suitability certificate given by the authority, it's not per se contrary to the American Convention on Human Rights. On one hand, because it considers that the right of parents for their children to receive a religious and moral education that is in accordance with their own convictions, recognized at the end of the Article 12 in the Convention. that may imply that religious authorities have the possibility of selecting the religion professors who teach classes on their doctrine. On the other hand, because it concludes that the degree does not distinguish between religions or establish differences in treatment between people based on their sexual orientation. Therefore, religious classes of a confessional nature, such as those regulated in the aforementioned decree, are considered to be according to the Convention. In fourth place, the judgment accepts the existence of the doctrine of the ministerial exception in the area of determining who are the members of a religious community, who are its ministers, and what are its hierarchies. Lastly, the court limits the effects of the sentence only to public educational establishments, respecting the autonomy of religious communities in the suitability certification of religion teachers when they teach classes in private establishments. Chile has a long tradition of religion classes in public schools, from teaching exclusively Catholic religion, and then as a first step towards religious freedom in the last half of the 19th century, allowing private teaching of other religions. Today, there are 16 programs of religion recognized in Chile that can be taught in public schools. A few years ago, in 2017, the fact of teaching religion in public schools were the subject of appeals in Argentina and Brazil, which were resolved in different ways. In an Argentine province, Salta, religion classes were planned from the 19th century and taught mostly Catholic religion in public schools, and the Supreme Court of Justice declared unconstitutionally of a section of education of that law, considering that it's discriminatory and violates families' right to privacy when asking parents to express in writing their intention for their children to participate in said classes. Then in Brazil, the Attorney General's office alleged that public schools could only offer religion classes as long as they were not about a specific doctrine and provided that it was a general exposition on the different beliefs, practices, histories, and social dimensions of the different religions. But the Supreme Federal Court of Justice of Brazil, which is a secular state, decided on September 2017 that public schools can offer classes of a specific religion as long as the course is optional for students without contravening the secularism of the state, since the discipline cannot be offered on a mandatory basis for public students. In this context, it's useful to take into account that Latin American countries, there are more states that don't have religious instruction classes in public schools than the ones who currently have them. There are optional religion classes in public school in Argentina only in Tucumán province, Bolivia, Brazil, Chile, Colombia, Costa Rica, Guatemala, Panama, Peru, and the Dominican Republic. Obviously, religion classes are not the only expression of the connection of religious freedom in schools. For this reason, the research led by Professor Garnett on K-12 schools and religion in Latin America, which seeks to provide global lawyering education, includes a compilation of the current legislation on the rights of equality and non-discrimination, religious freedom, and parental choices. The study contemplates an extensive examination in almost 30 countries about constitutional and legal disposition and judicial decisions, country religious profile, country educational profile, and going deeper in details about funding, autonomy, or religion classes. Of course, there are some difficult questions that you already addressed, even from what is considered a public or common school. Are those just the state ones, the private ones that receive financing from the state should be considered public, and private would mean that they lose some of their autonomy regarding teachers, employees, and student selections. On their curricular decisions also, they would lose that autonomy. The educational field is the one where there are more constitutional or legal norms about the secular state in Latin America. Mexico constitutionally establishes the secular character of the state and it's expressed in a secular education mainly, understood as completely alien to any religious doctrine. I may finish saying just that the protection of religious and cultural pluralism inside schools is undoubtedly one of the values and challenges of contemporary democracies. This means recognizing and promoting the peaceful coexistence of various beliefs and religions within the framework of respect and the exercise of human rights, also within public schools beyond religion classes. I would like to finish this presentation thanking Professor Garnett for leading this project, and I also thank Stephanie and the Religious Liberty Initiative for inviting me to this summit. I must say that being an alumni of the Greg, I'm delighted and thrilled to be here, and I do appreciate the outstanding organization that Notre Dame Law School, led by Dean Cole, has provided to this conference. Thank you.
Good afternoon or good morning. I hope you can all hear me. First, I would like to thank Notre Dame for giving me an opportunity to be here to share my experience on religious liberty in Kenya. The Kenya religious sector is broad, diverse, and complex. We are a multi-religious country, a multi-ethnic country. We are 81% Christian with over 300 registered Christian denominations. Please take note of that, 300 registered Christian denominations. We have a Muslim population of 11%, Hindu and Sikhs, they are 2%, traditionalists 2%, and we have other groups. Now, when it comes to religious liberty and the Constitution, Article 32 of the Constitution of Kenya provides that every person has the right to freedom of conscience, religion, thought, belief, and opinion. And every person has a right, either individually or in community with others, in public or in private, to manifest any religion or belief through worship, practice, teaching, and please take note of teaching, all observance, including observance of a day of worship. So our days of worship are Friday for Muslims, Saturday for SDAs, and Sundays for Christians. A person may not be denied access to any institution, employment or facility, or the enjoyment of any right because of the person's belief or religion. And a person shall not be compelled to act or engage in any act that is contrary to the person's belief or religion. Notably, the Constitution provides for Catholic courts to adjudicate certain types of cases based on Islamic law and the teaching of madrasas and duxis, which are Islamic. Now, the right to religious freedom. The right to religious freedom is not absolute. It can be limited based on reasonable grounds. The reasonable and legitimate limitation is in accordance with Article 24 of the Constitution of Kenya that authorizes some limitations. However, what is unreasonable right? The rights belong in itself a complexity, a right on one hand and an institution with its own religious observance, and that is what I would like to talk about. In Kenya, we have three categories of schools. We have public schools that are owned fully by government. They provide teachers, they pay everything. Then we have private schools. And under private schools, we have two categories. We have schools that are owned by religious organizations. Most of them are either Catholic, Anglican, or Presbyterian. And then we have private that are owned by individuals or international schools. Now, the church or the faith-based schools are in a category known as not-for-profit. They are not high cost. You'll find them in the back of Biod. You'll find them in the poor, in the slums, in the north, in the semi-arid parts. They serve the poor. and some of them provide everything. But they are fully private because the church provides everything. Then we have a category of schools that were started by missionaries in Kenya. They are the majority. They are the majority of the schools. They actually form over 60% of the schools in Kenya. Most of them are Catholic, Anglican, or Presbyterian. Those schools are on church land, land that was bought by missionaries or land that was given to the missionaries by the church. They continue the traditions of their founders, whether they were the Loreto sisters, the Precious Blood sisters, the CMM brothers, whoever they are. They continue those traditions. Even the ones that were founded by the Protestant, we have a lot of schools by Quakers, they still continue those traditions, very strong traditions, and they are the most popular schools in Kenya. They are good in character formation, they are good in academic performance, and that is where their interest is. So you find every Kenyan would want their children to go there. So what does the Basic Education Act say about religion? Our Education Act was revised in 2013 after our Constitution. And Section 27 says the following about religious sponsors. That the religious sponsor shall participate and make recommendations of review of syllabus, curriculum, books, and other teaching aids. So any curriculum that goes through in Kenya, whether it is we use one curriculum for both public and private schools. For international schools, their curriculum is vetted by government. And in the vetting, or in the Kenya Institute of Curriculum Development, the main church faith bodies, that is the National Council of Kenya, the National Council of Churches of Kenya, the Supreme Council of Muslims of Kenya, the Hindu Council of Kenya, and the Kenya Conference of Catholic Bishops sit in those panels, and there are series of panels. So they have a say on what goes on in the curriculum, which is very important. 2, representation in the school management committees. So in the schools that were founded by the missionaries, in the ones we call sponsored public schools, they're faith-based in the schools that they founded, they sit in the management committee. They have 3 representatives, and one of them is the chair. Now, the battle is always when the politicians would want to have a chair other than the ones, the faith-based ones, for reasons I don't want to discuss. Number 3, to provide supervisory and advisory services on matters regarding spiritual development in schools, including appointment of chaplains at their own cost. So the chaplains in Christian schools, in faith-based schools, are appointed by the faith-based body at their own cost. And this is very unique because when you look at the military, in the uniformed forces, the chaplains are appointed by the faith-based but paid by government. So one of the issues of debate has been, why is the government paying for chaplains in the uniformed forces but not in schools? Then number D, maintenance of spiritual development while safeguarding the denomination or religious affiliations of all learners. So just to give you an example, some of our big schools, Catholic schools, have a population of 3,000 children. In that population, less than 50% are Catholics. But you will find that the school makes provision for religious worship of the groups that are represented in that school, be they Protestants, be they Muslims. Arrangements are made through the chaplains. So do religious-sponsored schools, be it private or public, have a freedom to manage and administer the schools in line with their religious ethos in light of the individual freedom to religion? How can these schools protect their rights and maintain the demands of others. The Basic Education Act 2013 raised out the role of the sponsor, and a keen look at the same introduces a limitation by implication. The section defines the role of the sponsor to include provide supervisory and advisory services in matters regarding spiritual development in schools, including the appointment of chaplains at their own expense. Now, the Basic Education Regulation, Section 25 of 2015, Section 7.2 state that in case of sponsored schools, the concerned Board of Management shall develop the dress code, that is the uniform, in consultation with the Sponsors Association. Now, this has been one of the issues of religious liberty. In the recent past, we have had more than 5 cases where faith-based schools have been taken to court because of their dress code. And in one of the cases that I would like to cite, the Supreme Court of Kenya, in a case against the Methodist Church versus Apparent, in a case overturned a decision requiring the Methodist-sponsored school to accommodate a Muslim student in terms of dress code. The Muslim student wanted to be allowed to wear hijabs in exercise of their religion, their religious freedom. In this case, Muslim students joined a Methodist school and in the admission letter agreed to adhere to the school uniform. And this has become quite common. Students joining a Christian school and after some time making demands that pertains to their own religion. And the other issue is on religious education, whereby religious education is taught in basic education. But as time goes on, the government keeps on praying, reducing the lessons from 3 to 2, 2 to 1, back to 3 after demands by the faith-based. And the other issue is on comprehensive sexuality education, the right of the parents to choose what their children should learn. And the issue of comprehensive sexuality education is very sensitive in the East African countries. Why should parents not be consulted on what their children are being taught about human sexuality? That becomes a real battle between government, faith-based, and parents. And lastly, the issue of land. Land on which church schools were established by missionaries, bought by the churches, and the government, for reasons known better to itself, would like to claim that land without any compensation to the churches. Thank you.
So, Brett, while he's loading his slides, I want to just ask Augusta. I learned a lot about, I really got interested in this, learning from Augusta. And I one thing you didn't really emphasize that I think for us Americans at least would be very shocking is in these sponsored schools, as I understand it, the teachers are state employees and they are appointed by the government, and you do not even have power to select head teachers and principals except through negotiation. So if you don't like the principal, you just keep sending them back until they say, oh, unacceptable. But I mean, so this is like very core. I mean, these are church schools. They don't have any power over who is teaching and the students, which means it's very, very hard for the mission of the school to be carried out by teachers who are maybe very hostile to the mission of the schools. They're just public school teachers.
Thank you. Yeah, it is a difficult issue, and it depends on the current. For the last 10 years, it has been quite, I would say, easy in terms of we can sit and talk. We can sit and agree that in a school that is founded by precious blood sisters, we cannot have a person who does not understand the mission, the ethos of the precious blood sisters run that school. And it works one day, the other day it doesn't work. And the minute the churches come together, then they are listened to. Then after some time, the government overturns that. So you will find that The fact that the churches, the Christian churches are able to lobby together, that gives them the strength. The fact that they are able to, they have majority of the schools, that speaks volumes, and the fact that their schools perform well. So the issue is more so when it comes to the teaching of the region. Who teaches the region? Who decides who teaches the region? So you will have a person teaching Christian religious education, and they have no idea what it is all about. So that is what makes it difficult. And in the recent past, I think we have learned more to negotiate, to meet with government, to get the government to understand that things must be done differently. And this is more so because of the issue of radicalization. In the last 10 years, I think we have seen the worst of it all, and we have seen it in schools. So the government has come to appreciate that things must be done differently, and we must sit and talk, find out why is it these church schools are performing well, and what do we need to do to enhance that. And maybe through that dialogue, we'll be able to get the government to respect the religious rights of the faith-based organizations in schools. Yeah, thank you.
Good morning. I want to join others in thanking Dean Marcus Cole and Professor Stephanie Barclay for their leadership in launching the Notre Dame Religious Freedom Initiative. Also very grateful to my good friends Rick and Nicole Garnett for their long-standing work and leadership in this area. Nicole, it was remarkable to hear about the 25 years that you've spent working on the school choice issue. I feel a deep connection with each of our panelists. Our center has also organized conferences here in Rome. The last one was in conjunction with the dedication of the temple of the Church of Jesus Christ of Latter-day Saints, and we partnered with Catholic universities here in Rome on that event. Anna Maria, thank you for your discussion of the Pavez case. Our center was involved in both offering expert testimony and organizing a number of other pieces of expert testimony in that case. And the outcome was disappointing, but the rationale wasn't quite as bad as the outcome led us to initially believe. And our center is also helps organize 8 to 10 regional conferences a year, including a major conference each year in Africa. It was just in May that we were in Kenya, in Nairobi, for the ACLARS, the African Consortium of Law and Religion Studies Conference. Mark Hill serves on the leadership body of that organization. For those of us who are Latter-day Saints, we'll be very familiar with the famous conference address by President Dieter F. Uchtdorf, who talked about how to accomplish difficult tasks. And he was talking about a group at church trying to move a piano. And finally, someone suggested the idea, let's each lift where we stand. Where I stand or swim is in the deep waters of the intersection of law and religion. And I resonate deeply with the statement of Nelson Mandela that education is the most powerful weapon which you can use to change the world. We begin at home. I'm a professor at Brigham Young University, and for the last 25 years, my colleague Cole Durham and I have been teaching seminars concurrently at the same time, focusing on U.S. law and religion and international religious freedom. We encourage students to take both of these courses, and many of them write combined 40-page papers, which satisfies their religious, their substantial writing requirement. I'm also will be teaching these seminars this fall together with Dmitry Volk, a refugee law professor from Ukraine who will be a visiting fellow at our center, and Luftarun Saeed, an Afghani Muslim refugee who is also a fellow at our center, together with Holly Leeson, a former student. For our students, we have a number of programs, including a summer fellow program. This summer we have 15 fellows that have done international externships around the world, typically at the area legal counsel offices of the Church of Jesus Christ of Latter-day Saints. And they spend the other half of the summer working on academic and advocacy projects in our center. Our signature event each year is the International Law and Religion Symposium, which will be held this year for the 28th year. This takes place in the first week of October, typically involves about 100 delegates from 50 countries, interpretation into 10 to 12 languages. A number of you have attended this symposium at times over the years. And this is really run by a student executive committee together with more than 50 student volunteers each year. We also have a student management board, which helps us with our research and writing projects during students' second and third year of law school, and they also help us organize the regional conferences that we sponsor globally. We also participate in a variety of international moot court competitions. Andrea Pinn has been one of the key organizers of these competitions, often in the difficult to convince people to travel to spot of Venice. This year it will be in Cordoba, Spain, in conjunction with the International Consortium of Law and Religion Scholars meeting. We also have long-standing teaching programs at several universities, most notably Central European University, where Cole has been teaching for more than 25 years annually courses on freedom of religion, and I've been doing that with him for the last 15 years. We've also had opportunities to teach in other places. I was part of the first ever course on law and religion in Australia, and my participation there and the use of our textbook there got it integrated into the curriculum, and it has been taught regularly since. We've also taught at a variety of universities in China, including the China University of Politics and Law. One of the keys to our teaching is a casebook that we wrote that addresses law and religion, not just from a U.S. perspective. The best casebook of that variety is Rick Garnett's. Our casebook tries to do something a little different in teaching about law and religion with only about a third of the materials from the United States, a third focusing on international human rights law, and a third on comparative constitutional law. And this casebook has now been translated or is in the process of translation into a dozen languages, and it has become one of the standard texts that are used globally. We've also been involved in certificate training programs where we run 2 or 3 week courses globally focusing on religion and the rule of law. These programs typically bring professors from at least 10 different countries so that we can give a genuinely comparative perspective. We've been doing these programs annually in China for more than 10 years, although they've come to a halt, not just due to COVID, but also because of the political deterioration of international efforts in China. Early on, we had a leading scholar from Vietnam participate, and he asked us to launch a program of the same type in Vietnam. And we've been doing those programs annually in more than 7 different regions of Vietnam over the last 10 years. At one of those Vietnam conferences, leading religious leaders from Myanmar came, and this resulted in similar teaching programs being launched in Myanmar, which have continued online even after the military coup. At one of those programs, a government official from Laos came, and he asked us to organize a program in Laos the following year. Meanwhile, on a different track, we've been working with partners from Norway on a major teaching initiative in Indonesia on Sharia and human rights. And I'm pleased to announce that just this month, a course book on Sharia and human rights with chapters in both English and Bahasa Indonesia was launched at conferences both in Malang and Yogyakarta. We've also done teaching programs in Nigeria, in both Lagos and Abuja. At one of those programs, the dean, Marcus, shut down the whole law school, and the entire law school participated for about a week. We've also been involved in Uzbekistan, working closely with the government on law reform efforts there. We were most recently in Uzbekistan in May, where in addition to the certificate training program, there was a major conference on dialogue of declarations that resulted in an important new document, the Bukhara Declaration. I want to conclude by talking about what I'm doing this week after leaving here. We've initiated a program for young scholars at Oxford University. Each year we bring about 15 scholars. This year they come from 14 countries. These are people who have at least completed their PhD, and we have an intensive class which teaches them how to teach a course in law and religion. We also have 4 full-time legal writing instructors who are there to help many of these students who are not English as a first language speakers to learn how to write scholarly English language articles. And we've already seen that this is important not just for developing networks, but also for launching and accelerating academic careers. Many in this room have participated in these programs. As I look around, I see Mark Hill, and I see Andrea Pin, and Rodrigo, and Brian Grimm, and others of you may be interested in participating in some of these programs. If so, please let me know. One of the most important teachers I had in my life was the Reverend Timothy S. Healy, S.J., who was president of Georgetown University when I was a student. I worked in his office, and he took a liking to me. It was actually he who suggested that I apply for the Rhodes Scholarship, because he said, "You'll compete in Utah, and your only competition there will be sagebrush and guinea fowl." He said, "Even you can compete against that." Well, Father Healy took a liking to me and used to take me to lunch at the Jesuit residence, where he introduced me as his Mormon missionary. And Father Healy handed me, a business student, a tattered copy of his book by Cardinal John Henry Newman. And anytime I'm quoting the same person that Robbie George does, I feel like I'm on the right page. And this book changed my life because it was about the difference between education and training, and the importance of education for the formation of character and for engaged citizenship. And Cardinal Newman described education in a beautiful set of passages as an acquired illumination. Our goal has been to try to share this light in places around the world. And I'm grateful for the opportunity to be here today and to have this opportunity to just give you a whirlwind tour of some of the minor efforts we're making. We're a small center. We only have 3 full-time employees, and we endeavor and hopefully succeed in punching above our weight. But one thing we've learned in this area is that there is no such thing as drive-by activism that works. What's required is sustained, systemic, long-term engagement, including in places where that engagement is difficult. Thank you.
We, unfortunately, are really running.
Thank you. A very minor question, if I may. It ties together the first and last speaker, I think. What happened if we frame liberty, instead of using liberty, we used equality? So as a European, I can see the problem is having children coming from low-income families accessing private schools, because tax deductions are laughable, and you need to pay a lot. And of course, when the wage gap increases, you have lower numbers of people. And we usually frame that gap in terms of liberty. What happens when we talk about equality? You have low-income families not being able to access the same services and the same schools as more affluent families' children can. And I think it ties back to what Brett Schaff just said. You need to give everyone realistic possibilities to access global engagement of law and religion, for instance, like participating in a scholarship. I'm wondering whether switching the word, at least in some jurisdictions, would help the cause of religious freedom.
It's an interesting idea. The only thing is that in some political contexts, in some countries, you bring a lot of other discussion using this term, which can then be a kind of a drawback also to the presence of religious schools, which are not equal but different. It would be an interesting probably topic for a whole conference. But I'm very much, I think I will follow up to your suggestion.
So, go ahead, Augusta. I was going to say on that note, I'm excited to say that, well, some of us will be back in December. We're having a conference on religious liberty and Catholic education globally, focusing in particular on these topics. So this is just we're excited. This is like the prequel. But thank you all for being here, and lunch is served.